Next, the statistics about the total EOC charges. This is just a graph, obviously, and it shows you how significantly up the charges have gone. I probably, somebody once told me there's three types of lies, dang lies, and statistics. These statistics actually don't lie. I mean, the charge numbers are unbelievable how much they've gone up. I see employers going up 10, 20% anecdotally, so it's definitely something to be looking out for. The other cases that are very hot right now in Florida, and some of y'all may be familiar, for instance, with the Morgan and Morgan law firm, the For the People folks. They used to be called Morgan, Calling, and Gilbert. They're filing a ton of these wage and hour lawsuits. And normally these cases are really squabbles over a typically insignificant amount of money. Maybe somebody wasn't paid, 100 hours of overtime because they've been misclassified as exempt, or you are automatically deducting for lunch breaks, and they claim that they were never free to rest during a half-hour-long lunch break. Normally, we're talking about a very insignificant amount of money, but the plaintiff's attorney is going to want $5,000 or $10,000 for you to pay them in attorney's fees. Plus, you're going to have to hire an attorney to represent your interests, and oftentimes the plaintiff's also going to ask for what are called liquidated damages, which equal back pay. So, for instance, let's say you had a $5,000 dispute over a pay issue to an employee, and let's say the employee was right, you owed him $5,000. To settle a case like that, you're going to have to pay him $5,000 plus a second $5,000 in liquidated damages, plus your attorney's fees, plus the other side's attorney's fees. So you're very well looking at, on just $5,000 in disputed pay, $30,000 to $40,000 in resolving a case at the very beginning. I will be candid with you. I will be willing to bet that just about every employer on this call, if not all of you, have some wage and hour violation going on. I actually have a standing offer to my clients that if they let me conduct a wage and hour investigation and I don't find any violations, I'll write it off and do it for free. As you can imagine, I'm not in the business of doing things for free. I've never found an employer that doesn't mess it up. Even some of the largest employers, for instance, Walmart, who has an unbelievable amount of resources and a very sophisticated human resource and in-house legal team, they sometimes get sued for wage and hour violations. So if they can make mistakes, and I'm not saying they've made mistakes, but if they can get sued for these things, certainly you all as employers can. Florida right now, and particularly the I-4 corridor, has seen more wage and hour lawsuits than every other type of employment case out there combined. To make matters worse, there are more wage and hour cases filed in the I-4 corridor than any other jurisdiction in the entire country. So that means we have more of these cases than pro-employee states or jurisdictions you might think of, such as Boston or New York or San Francisco. There's more of them here than anywhere else. So that's certainly a hot-button issue if you want to know what the lay of the land is like. As far as the laws, back to the EOC that they look at, we're talking about Title VII, the 1964 Civil Rights Act, and as I said before, that's race, sex, national origin, and religion. Race, one of the mistakes I see a lot of employers make when taking analysis is reverse discrimination cases. For instance, they'll have a white employee complain that they didn't get some promotion because the employer had some sort of diversity program or affirmative action. My best advice when it comes to an issue such as race is treat everyone the same. Try to be colorblind. Don't have your own personal utopia. When you're making your employment decisions, your responsibility as an employer is to try to promote the best or hire the best possible, most qualified individuals. When you start factoring in things such as, well, we don't have enough females working here, or we'd really like some Hispanics here, you run into some huge problems. There are very limited exceptions as to when you could hire somebody based upon their race or national origin. For instance, some employers might say that an ability to speak Spanish is a plus. Well, that's fine, and if you've got a good reason for requiring that, that's okay. That's not discriminatory, because certainly somebody that's not Hispanic can speak Spanish fluently. But be very, very careful in making those type of decisions, particularly when it comes to race. The only other sort of unique part of Title VII, well, there's two other unique parts. Number one is religion. Religion has two components. Number one is you can't discriminate against someone based upon a bona fide, genuine belief. And the other is you have to reasonably accommodate somebody's religious observances. You noticed I said someone's bona fide or genuine belief. It does not have to be a recognized religion as you normally would think of it. I mean, we might think of Christianity and Judaism and Muslims and Buddhists or Hindus. There are lots of religions I guarantee you've probably never heard of. As long as someone's got a bona fide belief in it, you cannot take any adverse action against them, and you have to reasonably accommodate their request if, for instance, they have a particular religious observance. For instance, if you had a Jewish employee and they asked to take a sacred holiday off, you very well are going to have to accommodate them in doing that. The other unique issue is under sex, or as part of Title VII, sex, that encompasses sexual harassment as well. And there can be harassment under any of these statutes. So when you hear these big sexual harassment cases, they're all brought under Title VII. There are also laws that are state and local specific. For instance, the state of Florida has a law called the Florida Civil Rights Act, which is just like Title VII, but it also covers marital status and sickle cell trait anemia. Most local jurisdictions, let's take Tampa for instance. Tampa has their own ordinance that's just like Title VII, which will also cover sexual orientation. There is no federal law currently covering sexual orientation. However, there's a good chance, there's been a number of congressmen that have been talking about it, and there's a very good chance that that's coming down the pike. The next law you see on here is the ADEA, or the Age Discrimination in Employment Act. This law is somewhat unique that it only covers employees that are 40 years of age or older. So in essence, under Florida law, you could walk up to every 39-year-old and say you're fired, 39-year-olds are too old to work here. Now, again, that's legal advice, not practical advice. Of course, you don't want to do something like that, particularly since the Florida Civil Rights Act, or the Florida law I referenced that's like Title VII, it doesn't mention an age cutoff for like the ADEA does, and at least one court has found that it covers people of all sorts of ages. Stuff like under this statute comes up, for instance, if you see an advertisement that says, looking for recent college graduate. Well, recent college graduates typically are younger, and that's the type of evidence that somebody might use of age discrimination. Or if somebody has a 50th or 60th birthday when they're working for you, if somebody gives them, an ageist type card, you're over the hill now. Those type things are used as evidence of discrimination.